Today, we're going to talk about natural justice. It is one of the most important legal concepts in education. It can also be called fairness in legal procedure. This has to do with whether the law has been applied fairly, regardless of the actual content of the law. There are two basic concepts of natural justice. Number one, the person judging a particular situation should not be biased. Pretend that I had a bowl of cheese. Then it got stolen by the cheese bandit. I, as the accuser, cannot also be a judge in this scenario, even if I know that he or she took it. There has to be a neutral party involved to take care of proceedings. If you'd like a more practical example, let's think about education for a moment. If I'm a teacher and I accuse a child of something, it does not mean that I can then become a judge judging the accused, because I have a biased opinion based on what happened, even if I might have an idea what's going on. Number two, the person accused has the right to a fair hearing. It is only fair that the charge being made against them is understood.
I just found the bowl of cheese. I'm sorry, I thought it was up for grabs.
Even though that was a terrible excuse, and it is still my bowl of cheese, at least we give them the chance to share their side of the story, which only makes it fair. Hence, point is, the judge should not be biased, and the accused should have a chance to share their side of the story. That is natural justice. Essentially, natural justice deals more with procedural fairness than with the actual substance of the law. Think about it. People at institutions aren't perfect. For example, in a court setting, financial aid is often necessary to hire the most competent legal counsel. Consider a legal battle between students and their parents and the school board. Who will have the greater access to funds? Unless you're like a loaded 12-year-old, chances are it'll be tough to compete with the school board.
No matter what, got money on my mind, I can never get enough.
In all seriousness, though, that's highly unlikely. In regards to legal proceedings, one must also consider judges and their potential biases. It could be their particular view of a certain people group, or maybe they're just exceptionally harsh in handing out verdicts. I mean, I get it. Being a judge could be as frustrating as having your head stuck in a vacuum. But still, it's supposed to be fair. Let's just say that in the past, political decisions made through legislatures and school boards and that sort of thing have been more significant to schools than those made in the courts. This, however, is changing due to Section 7 of the Charter of Rights and Freedoms, which guarantees the right to fundamental justice and gives greater focus to this natural justice as it relates to legal matters involving education through the court setting. Later on in the presentation, we'll talk about the Charter of Rights and Freedoms in a little more depth. But for now, let's talk about rights. Many educational issues are framed as questions of rights. I'm a teacher. I have the right to voice my opinion about school policies. I'm a parent. I have the right to see my child's school records. I'm a child. Don't hurt me. These are common questions and comments regarding this concept of rights. But what are rights? Where do they come from? Rights can be identified as normative and legal, procedural and substantive, negative and positive, individual and collective, personal and property. Let's begin with normative and legal rights. Normative rights are the rights that people believe every individual should have, something we possess by virtue of being human, and a few examples include the right to a fair trial, the right to free speech, and the right to be free of discrimination. Exercising any rights, however, can only be done under 3 conditions. the right has been officially recognized through a law or rule. There needs to be a process for settling disagreements over rights. And there has to be a way for people to enforce a particular right. For example, let's say I'm a student who is expressing my desire to have Taco Tuesdays in the cafeteria at my school. There must be some law, rule, or policy that specifies this right for me as a student and as a human to have tacos on a Tuesday. There must be a forum for determining when and if tacos can be had or not. And finally, there must be a way for students to have that right enforced when it is violated. Like if they gave me fish pie instead. No one should be forced to eat fish pie on a Tuesday. Or any other day, for that matter. Now let's talk about legal rights briefly. Legal rights arise from normative rights. Legal rights are essentially normative rights that have been recognized and, over the years, have been advocated for to promote change. A prime example would be the journey for people with disabilities, in their ability to enter buildings, hold down jobs, and be part of normal life. Only in recent times have we seen a shift in recognition for these rights, but there's still a long way to go. Now, let's discuss procedural and substantive rights. Simply put, procedural rights are concerned with how things are to be done, whereas substantive rights are concerned with what is to be done. Procedural rights are important, but without a substantive right, they are insufficient, as each good idea needs a plan. Now on to negative and positive rights. These can also be called option rights and welfare rights. A negative right is the right to do something without restraint, where you are given a choice or an option. This includes things like free speech and free assembly. A positive right is the right to have or receive something. Do I buy this pair of underwear from the thrift store? A question like that would depend. Do I have the finances to make this purchase? Is there a thrift store accessible to me? When's the last time someone donated undies to the MCC? Probably recently. A fourth way we can think about rights has to do with individual rights and collective rights. Respecting the rights of an individual may impose constraints of some kind on the collectivity, whether it be a class, a community, or a country. For example, providing education to children with acute health concerns can be very expensive, but is borne by the community to meet the child's right to be educated. As well, the collective rights of minority language and religious groups may be protected even if they do not coincide with the wishes of the dominant majority. Finally, let's distinguish the difference between personal rights and property rights. Personal rights, as I'm sure you guessed, are personal and have to do with each individual member of a society. Everyone has the same amount of these rights, no more, no less. Property rights, on the other hand, belong only to those who, you guessed it, own property. The more property you own, the more rights you have. In our history, this has often taken precedence over the personal rights of individuals. This included things such as voting, union formation, and funds allotted to schools with greater size and more students. Like Steinbach. This concludes the video on natural justice and rights. I hope you learned something valuable today, and if there's even like 2 things you can remember, heck, maybe 3, all power to ya. Thanks for listening. So long.